The last concepts we're going to look at are in relation to IDEA principle number 6, mediation and due process. So it's important to remember as we look at mediation and due process that these are events that occur when an IEP team becomes contentious and an agreement can't be reached on services for a child. It is also important to remember that mediation and due process occur at the district level with district administrators and attorneys. They are not the responsibility of the special education teacher, other than you may need to be a witness in either mediation or due process hearings. So mediation is the concept where a neutral third party tries to help two disagreeing sides come to an agreement. Mediation was added to IDEA 2007 to try to decrease the number of due process hearings that were occurring. It is a voluntary event, and it is not meant to delay or deny any due process hearings. It must be undertaken by a qualified mediator, and SELPs generally keep a list of qualified mediators in their area. The district pays for the cost of mediation, as well as ensuring that all IDEA guidelines for mediation are met. So the process of mediation includes the following. Pre-mediation meetings. The district would meet to figure out a strategy, and the parents would meet with their support system to figure out a strategy. There would be an introductory mediation meeting with the mediator, and then there would be a mediation meeting, and this would include opening statements, an agenda setting, thinking of resolutions to the problems, hopefully figuring out and negotiating an agreement, and then the mediator would prepare a written document showing the agreement, and that agreement document is what gets transferred over to the IEP. If a mediation hearing does not go well and a parent decides to pursue due process, or if a parent chooses not to go down the road of mediation, which is their right because it is voluntary, you can have a due process hearing. Due process hearings have to be based on a violation of IDEA. So they can be a violation of identification, evaluation, placement, FAPE, and it has to be a last resort. Parents or school districts can file for due process, but they have to show that they've exhausted all other measures. Also, the hearing has to be requested within 2 years of the violation of the law. So this process includes the party, either the parents or the school district, files a complaint with the other party. A hearing officer through the courts has 5 days to verify that the complaint is about a violation in IDEA. The respondent, generally the school district, has 10 days to craft a response which explains why they have not violated IDEA. And then either the process moves forward or the parent drops the complaint. If the parent moves forward, there must be a hearing held within 15 days with a district representative. The district may not bring an attorney to this hearing unless the parent also brings an attorney. After that, if an agreement is reached, the complainant can waive their due process complaint, or they can request mediation if they feel like it doesn't need to go through the court system. If it moves forward, a resolution must occur within 30 days from the original complaint. So a due process hearing looks much like a court case. There are pre-hearing activities that the school or the school district would participate in with their attorneys, and also the parents would participate in with their attorneys. Then there would be a hearing. There would be opening statements, evidence would be provided showing a violation of IDEA, witness testimony would be part of this, including possibly testimony from you as the teacher and also possibly from the student. And then there would be closing statements. Then a report would be prepared by a hearing officer or a hearing panel. Generally, even though due process hearings are court cases, they are not heard by a judge. Generally, they're heard by hearing officers who prepares a report. That report must be prepared within 45 days after the expiration of that 30-day resolution period. And why does the district always comply with a due process hearing report, even if they don't agree with it? Because there is a stipulation in IDEA that a due process hearing report is the final say in a matter, and if a district does not comply with the report, they run the risk of losing federal funding as a punishment for refusing to heed the report. And that's it for mediation and due process. We'll talk about it a bit more in class and look at some case studies based on these two ideas.